Well, good afternoon, everybody. And we're going to get started on this panel this afternoon. There are some technical issues that we're trying to work out. One of our presenters, Argyri Panezi, is not able to join us today, and she's prepared some pre-recorded remarks, and so we're just trying to work out whether we can do that. If those remarks are not available, I'm told that they'll be made available after the fact, so there'll be an opportunity to review her work after the fact. So I'll start by introducing myself. My name's Tim Outerbridge. I work as the Registrar of the BC Court of Appeal, so I probably work in the shadow part of the presentation. And I'm looking forward to hearing our speakers today with their ideas about how I and other justice actors can try to bring light to some of the work of the courts. So we're going to start off today, and I'll introduce our speakers as they go. Jérémy Boulanger-Bonnelly is an assistant professor at McGill's Faculty of Law. His research focuses on access to justice in civil matters, primarily comparative methods. His current projects focus, among other topics, on people-centered justice, on the role of public participation in improving access to justice, particularly through lay courts. His work extends to various aspects of private law, civil procedure, judicial institutions, and constitutional law. And as I was preparing for today, I actually spent some time reading Jérémy's paper, Person-Centered Dispute Resolution, The Potential of Lay Courts, which is in the 2024 edition of the Canadian Journal of Law and Society. It's an excellent read. It discusses how it is possible to have justice in courts run by those that without law degrees, and the experiments that have been undertaken in the UK and elsewhere on those subjects. So I commend that paper to you, and Jérémy, I'll let you take over in your presentation.
Thank you for that. It's not every moderator who reads your papers, so it's a nice touch. Good afternoon. It's really a pleasure to be here. I'm going to start my timer to make sure I keep track of time myself as well. So the presentation today is really a work in progress, and I'm really looking forward to having a discussion with you. It's trying to further the discussion on access to court data, because there has been, of course, a few papers on that, discussions, but we're not really getting anywhere. And so the project really starts from a personal experience I had a few years ago. I was conducting a survey on class actions, and there was interest from practitioners, but also judges, in giving information and responding to the survey. So I get my university's ethics approval, everything's fine, and then I circulate the survey. I get answers from a lot of practitioners, and then Chief Justices in various courts refuse to circulate the survey to their judges for various reasons, but mostly because of judicial independence. That's the word they used. And so I was a bit frustrated by that, and I started thinking about why access to courts is refused in that way, particularly to researchers and particularly to academic researchers. I also know that I'm not alone. Many people have faced closed doors when they try to access court data and to access judges in particular to do research with them. And yet we know that quality empirical data is necessary if we want to improve access to justice. This is the theme of the conference, after all. So how do we get there? How do we overcome these obstacles? In my view, courts should realize, of course, that they need to open up to researchers, and not just on an ad hoc basis based on their discretion and when they feel that they can give access to their information. If they don't, and maybe this is going to sound provocative, but I think they should be forced to open up through legislation, a bit like freedom of access to information requests. And I don't think that would infringe on their independence. Of course, it would have to be tailored, but I don't think the measure itself would infringe on their independence. Fortunately, I don't think we need to get there. I think we can build collaborative solutions between researchers and courts, and I'm going to close the presentation with an example that I think can be inspiring for the future. So my presentation is going to go in 3 steps. First, I'm just going to present briefly the data we already have about courts. Second, I'm going to identify what's missing, in my view, and what obstacles prevent us from getting these other pieces of information. And finally, I'm going to get to those solutions that I think we could implement here in Canada. So first, which data do we currently have? I'm going to go very briefly over that because many people had discussed this, especially Sarah Sutherland. If you haven't read her book, 2022, on legal data and information, it really canvasses the topic. But essentially, we have a lot of information about individual cases, and we can find that information in various sources. Well, we don't have a lot of aggregate information. That's not going to be new to anyone here, but that's the state in which we are. Of course, that individual information about cases is important, and we can get it through decisions, which tell us about identification of cases and also the substance of these cases, so the types of claims, the outcomes, the type of people that are involved in these cases. We also have court records, which are generally available, although behind paywalls or not available online in some jurisdictions. And those also provide us helpful information about the substance of cases through the documents, exhibits, filings, transcripts, recordings, and all of that. We also have court dockets, of course, which also provide us individual information about cases. And, of course, information about case management, so how the cases progress through the system, the different times that it takes for cases to progress. What's interesting is that in recent years, there's been a fourth source of information that's been added to that, and it's courts themselves that have started to publish information, not about individual cases, but about aggregate data on their operations. And so the first step in this project was to look exhaustively at all these reports that exist in different courts and to see what is the state of that information we have that is published by these institutions. And of course, it's very slim. There's not much there, to be honest. And it's very imperfect in the way it's published in different jurisdictions. So some courts are going to publish yearly reports in which they're going to give some general information. And when we look at most reports, what they all have in common is that they report on cases initiated, cases disposed of in the year, and the time it took to get from A to B. So that's very basic information. Other courts are going to go further and report also data about, for instance, the number of hours they had in hearings, the number of hearings, other forms of disposition, judicial mediation, so these different indicators. But it's very piecemeal, it's very unequal, depending on the jurisdiction you're in. There's also British Columbia, which I wanted to mention, which has an interactive dashboard of information, but essentially it's the same information as we have in these reports. So we do have some information about the court system, but my second point is that there's a lot missing from that information, of course. First, while we have a lot of information about individual cases, as I mentioned, that information is technically accessible, but it's not in a format that allows us to do a lot of research. So we don't have aggregate data from these individual indicators, and Simon is going to talk more about that, of course, with his research on court decisions specifically. On the other hand, we do have aggregate data from courts, as I mentioned, through their reports, but this is very irregular. Some courts have never published any report, any statistical information. Others publish sometimes every year, sometimes every 2 years, sometimes every decade. So it's very unequal in the way information is made available. Even when we have aggregate data from courts, that data is impossible to disaggregate afterwards and to get information that would be very helpful to draw conclusions that are a bit more helpful than just general court management. And so the time to disposition, for example, is very important from a court perspective, but it doesn't tell us a lot about who takes more time to get through the system, which types of cases, which type of people, are they self-represented or not. So that kind of granular data is missing from what we have currently. And finally, the other part that's missing, and I think that's the most important part, is the people-centered and person-first information. Those two terms are a bit different, so I'm going to go through them quickly. The first one is person-first information, and that's a term that Lauren Soudal, in her work in the US, has coined to essentially say that we should shift our perspective from having the case as a unit of information in our system to people as the unit of information in our system. So instead of looking at how cases progress through the system, we should look at how people move through the system, because people, of course, can be involved in many cases in many different ways, and even not as plaintiffs or defendants, but perhaps just as part of another case in a different way. So to get a better picture, Lauren Soudal tells us we should have that kind of person-first data. And the other type of data that's missing is person-centered data or people-centered data. And that's the data that we don't collect currently because courts don't have the resources to do it. But essentially, what is the perspective of people going through the system? What is their sense of access to justice? What is their sense of satisfaction when they go through the process? So what are the obstacles that prevent us from getting these types of data? The first hurdle is really the lack of willingness from courts to publish the data they currently have. Some courts are going to publish that information, but by giving access only to a select few individuals when they ask for it, and on conditions that the courts are going to impose on the use of that information. Some people were dissatisfied with that, so there have been some attempts to try to force courts to give up information, and those have been largely unsuccessful with some exceptions. And so I reviewed the case law around that topic to see what arguments were made and which arguments were successful or not. The first approach was to go through the Freedom of Information and Protection of Privacy Act. In Ontario specifically, there's not much case law around that in other provinces. But in Ontario, some people have asked through that Freedom of Information and Privacy Act to have access to some court data. And of course, courts are not subject to that legislation, so you can't directly ask courts to reveal information using that mechanism. But the executive has a lot of information about courts that is provided either by the executive itself or by the court to the executive. What courts have said in that circumstance is that such requests essentially concern information that is perhaps under the custody of the executive, but not under the control of the executive. And therefore, it can't be disclosed under the Freedom of Information and Protection of Privacy Act. And the other reason that's been invoked in these cases is judicial independence, which, according to the case law, reserves entire discretion to the court to decide which information to disclose and in which way. So someone was also dissatisfied with the state of affairs in that case, and some of you may know about the Michael Lesage case, which went through the courts in Ontario. Michael Lesage is a lawyer and wanted to have access to some court data. And he argued not only that he should have access to that information, but that the open court principle mandated that kind of access. The court also threw that argument out, and what the court said was that the open court principle has evolved to give us access to hearings, to give us access to court records, essentially on an individual basis, but it doesn't give us access to court operational data, to aggregate information that courts may have, and certainly it doesn't ask the courts to create that information, to create aggregate reports of their operations. And so these two approaches, of course, have failed largely, and they suffer from limitations. Even if you get information through these processes, you get already packaged information, and you don't get the kind of granular and person-centered data that I was mentioning before. So there's no legal mechanism to force courts to give up that information, but I would argue that there's a moral imperative on courts to give that information, especially to researchers. And the reason for that is that the open court principle is premised on some principles, some underlying rationales that apply with even more force to the type of information we're discussing here than to individual case information. Why is that? Because the open court principle is premised on the idea that we have to hold courts accountable. Paul Adderman was mentioning that this morning in the keynote panel, and I think it connects really well to the open court principle. And the open court principle requires transparency from courts to improve their legitimacy in the eyes of the public. So these three rationales combine to also support the idea that courts should give up that kind of statistical information. Courts have invoked a few other principles in response to that to say we shouldn't be compelled to disclose that information, and that's the reason why they don't voluntarily give it up either. And so these few reasons, the first one is, of course, judicial independence, which I mentioned earlier. But what struck me when I received that answer from the courts, and also in the case law, what we see is that judicial independence is used as a trump argument, essentially, not down south, but a trump card, essentially, to refuse giving up information without particularizing the link between independence and the actual information that is requested. Of course, I can understand that some information, the drafts of decisions, the memos that go on inside the court, they're covered by judicial independence and they shouldn't have to be disclosed. But information about statistical information, how the cases progress, really I fail to see the link between judicial independence and that kind of information, except perhaps the fact that courts would be a bit more accountable should that information become public. The second argument that is made often is the confidentiality of information. And again, this morning we heard that argument. But in the context of academic research, the argument really doesn't hold. because of the fact that within universities, of course, we have to go through ethical processes, and we're used to dealing with confidential information. If researchers in health can do it with information that is as sensitive or more sensitive than what we have in the justice system, I think we can also do it. And finally, resources are a huge obstacle. Courts don't have the resources to produce data, but again, researchers can come in. And with resources from grants, when we do get some grants, we can come in and use that information and essentially collaborate to create data and analyze it. And there's also a broader point here, which is that even if we were to give more resources to courts to produce their own data, it's not necessarily entirely what we want. Researchers have also their own independence, and so they ask questions that maybe courts are not going to ask. They create information that courts are not going to create. And so letting in researchers is different qualitatively from giving resources to courts, which we also should do. So in conclusion, what can we do to change the tides and respond to this? I think courts first have to realize that they should be a bit more open to researchers, and that collaboration is the key here. And they should do it not on an ad hoc basis, based on their own discretion of when, how, and to whom they want to give information, but they should open up to the whole of the research community. And if the judiciary continues to refuse access, as I was mentioning, I think it would be legitimate to have legislation compelling the release of some information. And again, I don't think the judicial independence argument would hold for the type of information we're mentioning here. But I think the better way is to have a collaboration between researchers and the courts. And what could that collaboration look like? Here we can look to the south of the border, so not to Trump, but to organizations in the United States. There's specifically the National Center for State Courts, which is a nonprofit that was created together with the Conference of State Court Administrators. And they have developed standards to collect data, to analyze it, to publish it as well to the public. And they have standards that are established together between the judiciary and researchers to alleviate these concerns that the judiciary may have, but also to make information public in a way that is structured, that is systematic, and that is helpful for the community. There's also other examples, but I'm pretty much out of time, so I'm going to stop here. But I do think that we have to build these institutional collaborations outside of government for one other reason, which is that the federal government cannot really be in charge of that because of provincial sensitivities, especially coming from Quebec. I know a bit about these sensitivities. And so I think having that kind of separate independent organization together between researchers and courts is one way forward we could use to make sure that we have access to data for access to justice. So that's my idea. Looking forward to hearing more about what you think of it.
Right. Well, I have a couple of thoughts on that presentation, Jérémy, but I think we'll return to it after we hear from Simon Wallace, who is an assistant professor at Lincoln Alexander School of Law at the Toronto Metropolitan University. He studies how how modern computational research methods can be used to ask and answer new categories of questions about Canadian law. He's a former refugee lawyer, and Simon has appeared before many courts in Ontario and elsewhere. And again, just sticking with the theme of papers, I really do commend Simon's paper on access to algorithmic justice. And he introduces in that paper a lot of what he's speaking about today, but it's a more detailed analysis of the work that he's done, which is to be commended. But I think we're going to get into the weeds onto some more detailed aspects of how AI and other systems can help us really get into the data. So let's talk about that first, and we'll come back to questions after.
I get so self-conscious when people introduce me because at the end of the day, I'm just a simple lawyer, a simple law professor, which means do I have slides? I might have slides, we'll see. Which means that I just like judicial text. I just like to read what the judges have to say. Partly that's because I'm a lawyer, and as a lawyer, there we go. Don't read that. Don't read that either. There we go. As a lawyer and as a law professor, this is what I'm trained to do. And so just even though we've talked today about how there are lots of different types of data that we're interested in the justice system, today, as far as we're concerned for this presentation, we're interested in judicial tax. And there are lots of good reasons to be interested in judicial tax. The classic reasons. We learn from judicial tax. We reason from them. It's where precedent lives. Also new, exciting, modern reasons to be interested in judicial tax. We're accustomed in our profession to reading text closely. One of the really exciting things about the AI moment is we can read and engage with unstructured text in new sorts of ways. So if you had a million years and you wanted to read every single case produced by the Canadian judicial system, you could learn a lot of really interesting things. You could notice patterns, you could notice trends, you could see debates that justice system participants have even spotted. And we can kind of start to do some of that now with new computational methods. Bottom line, we'll get back to some of this, bottom line is that judicial texts are interesting. The good news, thank you. We've got one person who agrees. The good news is, in this country, we have excellent data sets of judicial texts. We have like world-class data sets of decisions from British Columbia, from the federal courts, from administrative tribunals. And we can do amazing things with those texts. The problem is we can only do amazing things if you're rich. We only have access to those data sets if your name is Thomson Reuters or LexisNexis or OpenAI or Anthropic or Harvey. In Canada, as in many places around the world, there's a digital divide growing where people with resources are able to do the really interesting categories of research using unstructured text and discovering all sorts of interesting things in the data. So we know, for instance, that landlords are doing all sorts of big analyses on landlord-tenant board decisions and learning things about tenants. There's an asymmetry. Tenants can't do the same things for landlords. This is the problem I want to talk to you about today. And part of the reason I really want to talk about it and the thread that's going to be, well, the main argument that I'm going to be making to you is we've tried so many times to solve this problem in this country. We've been working at this problem since the 19th century, and we keep getting waylaid, especially in English Canada, by the profit motive. That we have incentivized people or authorized people to collect rents from a public good, the law. There's judicial tax. We've authorized people to say, if you collect them, you can sell access. And even though the justice system is creating it, even though it's a public good, someone else can create it. And most recently, we all thought that we solved this problem because of Canley. Canley is extraordinary. It is amazing. I use it every day. And when I say use it every day, I use it multiple times a day. It is a great, tremendous resource. There's a lot of data in there, a lot of judgments. And it's just right out there. But if you're someone like me who's interested in doing big analyses on lots of texts, on lots of things, you can't do it. You can't read this, but I'm just going to tell you what it says. You can't do it because Canley won't share its data, and they won't let people like me who know how to code scrape the data from their website. So even though lawyers, all the lawyers got into a room and they said, the law is a public good. It should be made freely available. The way, and it appears to be freely available, it is not freely available for interesting new computational methods in the AI moment. And data is the whole ballgame right now. And the fact of this means that it's only the wealthy people who can pay to play who can get to engage with it. So I want to talk to you a little bit about how we got here and then what a few of us are doing to try to remedy the situation. Okay, we're going to go back in time. This is going to be fun. I didn't see a lot of excitement in the room when I said that. This is going to be a lot of fun. The Supreme Court reports. So the Supreme Court puts out a case reporter. And everyone here knows the story of the reporters. It used to be the reporters in England and America. They were reporters. They were journalists. They went to the courts and they reported on what happened and they published it and they sold their books, their reports of what happened in court, and lawyers would purchase them. When the Supreme Court was founded in 1875, one of the really exciting things in the Act, and you can go back and you can look at this, is Parliament said, okay, Registrar of the new Supreme Court, you got to put out your own reports. We have problems in this country. It's small. There aren't a lot of reporters. We're not happy with what reporters are doing. The Supreme Court of Canada, you're going to publish your own reports. This was, as far as we know, the first public reporter in the entire Commonwealth in Canada. We're access to justice leaders in this regard. The problem is it was bad. They did a bad job. And lawyers just complained and complained and complained about how the professional reporters were better than the registrar. This is my absolute favorite example of why these were bad. The early days, the idea that there are going to be written reasons every time, it's still an evolving norm. And if you look at the footnote, you can appreciate the challenges that our poor registrars have. The learned judge, having mislaid his judgment, directed the report to report the case without it. This is in the Supreme Court reports. They were just filled with problems, missing cases, lost cases, typos, all sorts of problems. So even though we had the Supreme Court reports of the early days, private publishing, sort of maintained, the private publishing was the only real game in town in Canada. I think there was a missed opportunity where the Supreme Court reports weren't properly resourced in the 19th century, never became an exciting project, and private publishing just remained relevant, dominant throughout the 19th and early 20th century. We're going to skip a lot now and go 100 years later. Another extraordinary Canadian innovation is the fact of digital search. Digital search for case law it begins to show up in the 1960s around the world, but one of the sites where it was really being developed was in Kingston, Ontario at Queen's University, Quick Law. Quick Law was a project that started at Queen. And this is what Quick Law looked like in the 1970s. Quick Law begins because, and again, you can't make this up, IBM was subject to all these antitrust suits in the United States, and they were just getting hit by sort of motion after motion after motion from the Department of Justice. And their legal team went to the engineers and said, could you build like a database of documents? And they said, sure, we could do that. And then the marketing department was like, wait, a database, we could sell this technology. So early database technology, one of the early test use cases was with legal data and legal decisions, particularly at Kingston with Quick Law. Project was led by Professor Hugh Lawford. And I would like to call Professor Lawford an anarchist or a pirate, an open source pirate. This is him in what was it, 1970? The whole point of computerized information systems is to enable more people to have access to more information more quickly. And it would be unfortunate if the effect of computerizing information was to make it into a valuable commodity and restrict rather than expand its use. Okay, so you see my thesis. So I made this claim earlier about the 19th century. The law is a public good. We should publicly resource it. We should ensure access, Supreme Court reports. But if we don't do it properly, private publishing is going to keep going. Lawford's making the same argument. Interesting things can be done with computerized access. And it would be a shame, Lawford claims, and I agree with 1970 version of him, it would be a shame if this became a private enterprise, something removed from the public good, something that you had to pay to access. Problem is, IBM and the Department of Justice withdraw funding from Quick Law pretty early on. And Lawford went to Queen's University and said, do you want to pick up the bill? And they said, we can't afford it. And he believed in his project, and he was right to believe in his project, so he took it private. He took it private, and it became, throughout the 70s and 80s, as we know, an extraordinarily profitable product. Quick Law. He licensed it to Westlaw. That's how Westlaw got its start, and raised quite a bit of money, creating the informational environment that we know today. Something different was going on in Quebec. In Quebec, there was a research lab similar to his, so Quick Law in Kingston, Datum at the University of Montreal. Datum eventually moves in-house into government, sort of like a crown court, and becomes part of SOGIP. And so there's a different story going on in Quebec, where the information, legal information is finding itself in a public governmentally funded repository. And things are not perfect in Quebec when it comes to access to legal decisions, but quite a bit different than in English-speaking Canada. The 90s. Who remembers the 90s? And it wasn't an exciting, yeah, two people remember the 90s. I don't know what, oh, I'm getting punchy. Remember, in like CD-ROMs were starting to arrive. And so what the big innovation of the 90s was, up until the 90s, if you wanted to access the computerized products like Datum, like LexisNexis, like Westlaw, you would have to pay for a specialized computer terminal to be installed in your office. To an extent, the 90s represented democratization of digital knowledge and digital information about court decisions, because they can push these CD-ROMs. And so for the low price of many thousands of dollars, a lawyer could subscribe to a CD-ROM service and get regular-ish updates to law and have it available to them at their fingertips in their office. This is the moment where you can really begin to feel our modern reality creep in, right? That if you have the money, you can have the information. And people will pay to have the information because lawyers can do things with that information. And using new search methods, they can do more things with that information. The feds and many provinces are looking at this environment. They're looking at the advent of the internet, and they're saying, you know what, we want to head this off. We're not happy with the fact that people are charging a lot of money for this quick law product, and then only some people can have it. So in 1997, we get the reproduction of federal law order, which reaffirms, some people say is more than reaffirm, our rights to copy federal law, copy decisions and statutes and things like that. This is really in the shadow of the internet. Back then, it's funny to go read the reports because they're like, have you heard of the information superhighway? Which is not what we call it anymore. But it was because of the information superhighway that they felt a need, the feds, to ensure that people could access law that way. Okay. This is another tragic story, or in my telling, this is a tragic story. So we get another lab. We get another Lawford. We get Daniel Poulin at the University of Montreal, and in the 90s, he creates this new lab called Lexim. And this is the first version of Lexim on a Gopher site. Gopher was an early rival to the World Wide Web. Didn't catch up, but it was cool. Poulin's idea, his big idea, was that we can publish law on the internet. Okay? And like in 1993, this was a revolutionary idea. We could publish law on the internet. And if Lawford was saying we can digitize information, Poulin was saying we can democratize that access by putting it on the internet, and anyone with any computer one day in this fictitious future will be able to access the internet. And so his research project, and it must have just been tremendously exciting, was to take the cutting edge of technology available to him at the time and buy servers and do all sorts of things and create early websites so anyone in Canada or in the world could read the law. And he works with the Supreme Court. He works with other sites to digitize their projects. And to us now, like, this looks very unsophisticated, right? We can just see what he's doing. He's scanning and putting up essentially PDFs of the normal Supreme Court reports. But this is exciting, groundbreaking stuff. And like the internet and the information to access regime we're accustomed to today is downstream of this. Meanwhile, while he's doing that, so we've got a few things. Okay, I've thrown up a few balls in the air. Let me point out all the balls. So we've got Lexim at the University of Montreal, and they're exploring how we can publish internet online and publish legal information online. We've got the CD-ROM business thriving. We've got the Fed saying, we're not wild about this. The law is a public good. Anyone should be able to copy it. Meanwhile, also, we've got CCH. Anyone do copyright law here? Okay, this is a blockbuster case. This is the thing. So CCH, here are the facts. Oh, I'm sorry, I did that. Here are the facts. The facts are that the Great Library in Toronto had a service where any lawyer could call them and say, I want a case, and they would photocopy that case and they would mail it to them. And eventually, CCH, Thomson Canada, a bunch of the big legal publishers said, no, haven't you heard of copyright? These books you're photocopying, they're ours, and you can't photocopy them without paying us. And this goes all the way up to the Supreme Court, and the Supreme Court issues an extremely progressive decision and gives us the modern copyright law regime. But while it's working its way up, late 90s, early 2000s, all the federations, all the law libraries are freaking out. They're very worried that the case could go the other way. And so they band together with the federation and produce CanLII. Long story short, the way CanLII works is that the federation would create CanLII, and CanLII would contract with Lexham, the University of Montreal. So Lexham will be the technology provider that can and produce the CanLII product that we all know and love today. It is, in this moment, an extraordinarily exciting story. And everyone's happy. Here's Boulanger. The goals of the academics involved in CanLII were clear: to increase access to law, to develop Canadian know-how in the subject field, to create a place where research on computerized legal documents can be conducted, and to offer training for students. It's a good story, right? Like it makes me feel, it makes us all feel good. I don't know who you are, but I'm so glad you're with me on this. Unfortunately, I don't know if anyone here has heard about the profit motive. And so there's this fun anecdote. So this is Poulin writing, recollecting a coffee meeting he had with Lawford. Around coffee, Professor Lawford told me in his just mischievous manner that Lexham will end up as a business. I disagreed without much nuance. Later on, he took the check and we split. This is what is called foreshadowing. And it's just like right here that my jokes are landing. And so in 2007, I think it was, Lexham is removed from the University of Montreal. It becomes a private corporation. And by this time, Lexham is providing lots of services to a number of courts. That's providing a bunch of revenue streams. And then in 2018, CanLII convinces the Federation and the law societies to purchase Lexham. And so for several $million, CanLII purchases Lexham and brings it in-house. Here's my theory. My theory is that on the one hand, this makes quite a bit of sense. If you're the Federation, if you're CanLII, you know that the one thing lawyers hate is paying fees. And you know that it's going to be always hard to go to lawyers and say, can we increase the remittance that is going to go to CanLII? And so it makes a lot of good business sense to bring Lexham in-house. Lexham has revenue streams. They're an international player in the court digitization space. And it makes good business sense to formalize this relationship and diversify CanLII's revenue streams. The problem is, in my view, and I can't prove this, but in my view, it creates perverse incentives for CanLII to keep its data close. One way to ensure that that Lexham maintains its competitive advantage on the marketplace, particularly the Canadian marketplace, and to ensure that other competitors don't emerge is by keeping the data around which the CanLII core Lexham product is built in-house, and this way other competitors can't arise. I mean, I'm pretty close to being able to prove it, but I can't prove it. But unfortunately, distressing things happen. So during this time, for example, okay, you're not going to be able to read this, so I'll just tell you what it says. So I'm a refugee lawyer during this time. And one thing which has recently come out and causes me some frustration is in refugee law with Professor Sean Rehags, the co-director of the project I'm about to tell you about, was doing all sorts of really interesting work that was really changing the practice of refugee law by applying computational methods to decisions. He was always limited because he couldn't get access to the data. What we recently found out, though, is that, well, me as a refugee lawyer couldn't have access to all the data, or more specifically for me, that Sean Rehag couldn't have access to the data and help inform our advocacy. Meanwhile, what we've recently learned is that Canley was playing by different rules for different people. And so Canley was giving the Department of Justice free access to its data during this time, while denying access to legal aid clinics, denying access to Professor Sean Rehag. So doing different things, which is, as someone who was paying fees and was litigating against the Department of Justice, sits uneasily with me. Okay, so I'm over time. So we're doing something about it. Can I take 1 minute? We got time? Yeah. Okay. So, I would like Canley to change. Maybe Canley will change, maybe it won't. Maybe you're on the Federation, maybe you'll tell Canley to change. I don't know. Anything could happen. What we're doing, so Sean Rehag and I, we're co-directors of this project, is we are collecting as many legal decisions as we can, and we're publishing it ourselves. And so if you're interested, if you're a coder or if you work with coders, we have these mass data sets and you can download them. You can work with them. You can do research on them. You could build an alternate product. You could establish a startup. You could do whatever. And so this is the main thing we have, is we're publishing data. We've got about 200,000 decisions right now, more than this figure suggests. We also have an API that allows people to just sort of pull one decision in at a time. We won't worry about that. You can do all sorts of new interesting analyses. And so we've been talking about readability and access decisions. You can measure, say, the aggregate readability of, in this case, tax court decisions. Way harder to read in 2025 than in 2024. And then the last thing I'll say is join us. Join us. In the spirit of Professor Lawford, we should all be pirates again. This is a time where data is the new game, and we need to make sure in this country that data is not something that just belongs to wealthy litigants, but is available to legal aid clinics, small practitioners, self-represented litigants. And we need to make sure that we are breaking down the barriers that prevent full access to data instead of maintaining them and repeating this story that's been ongoing since the 19th century. But let's talk about it later.
I think that's probably a good place to take a pause here and maybe deal with a couple of questions. Does anybody on the panel have any questions for Simon or? Okay, well, I have a couple questions. Well, one thing that I'd like to do is, seeing as we have everybody up here, maybe I can talk about the experience that I've had in dealing with people that are researching and wanting access to court data. In fact, a scenario that I had where I was reforming the Court of Appeal rules in British Columbia, and a researcher came along and said that they wanted to help with one of the aspects of that. And so just to play it out for you, and I know this has been alluded to, but one of the main anxieties that I have is about the quality of the data that I have, and I put it right up front in the Court of Appeal's annual report. I do not have high quality data. I don't have a data scientist. I am responsible for producing data. I am not a data person. I'm a lawyer. I'm a registrar. I sit in court most of the time. It's not my area of expertise, but nonetheless, I produce an annual report that has over 50 indications. But look, the main issue where, this researcher came, said, I want to do this research. First thing was, I'd like you to support my SSHRC grant. Oh, well, I'm sorry, I can't do that. We're an independent court. That's going to be problematic. Then we got into the process of releasing that data to the academic, and of course, academic independence. It's not my business what that person wants to do with that data, but we come back to context. The data that I'm producing, I don't have a proper system for inputting that data. The people that are inputting the data don't know necessarily what they're inputting. So it's not very good. And so I want to explain to the researcher, the full context of that data, but I don't have time to do it because I manage a docket of 1,100 cases and I have 8 people. in the court registry that are doing that. So, I don't like to stand up here and sit and talk about resourcing as the problem. But, I don't think, at least I can speak for the Court of Appeal, that, we don't plan on hiding behind judicial independence, because I think there's a big difference between administrative and adjudicative independence. And there's no basis for a court to say that they don't have, that they have judicial independence when we're talking about administrative data. But there certainly are issues with the quality, and I think if I were to have it right, I think a lot of courts have a lot of anxiety about releasing information, not so much because of the subject matter, but because of the quality of the information they have. And the concern that the impression that will be gleaned from that data will be inaccurate. And as custodians of that information and the responsibility the courts have to the public, that data is going to be misinterpreted. And I think academics often think that's because we expect they're going to do things with our data that we don't like. That's not it. It's just that the data itself doesn't have the necessary integrity. So I'll throw that out there and see if maybe Jérémy wants to comment on that or Simon wants to comment on that, because that's the main issue that I have.
And that's a very real issue, of course. Hopefully, that's not going to be an issue too much, maybe in a decade or so, when courts have transitioned to new systems. We heard the AG of Ontario telling us about the wonderful new system in Ontario. In Quebec, we're also changing the system. So hopefully, that's going to produce more accurate data, better data. So that's one point. The other one, in terms of independence, even supporting a grant to shirk, my perspective on judicial independence is that there's no issue there. Why is that? The courts are intertwined with the executive in many ways, as you well know, and the resources ultimately come from the executive in large part. So asking or supporting an application that goes essentially to the executive shirk to get money to do these kinds of things, I don't see that as a huge problem of judicial independence in itself, but I know people can have different opinions on that. But on the reliability of data, that's where I think the example of the National Center for State Courts is also interesting, because they have these committees where people can talk and contextualize that data and develop that understanding of what do we have, how do we present it, without infringing either on judicial independence or academic independence, but building collaboratively that understanding and making sure that what we publish is right. And academics are going to get it wrong often, but that's also, I think, part of the problem we have to manage.
Simon?
I just need to be super clear about this up front. Because I do computational stuff, sometimes people think I'm like a big AI person, and I don't want that to be who I seem to be. However, I'm not sure if you've heard of AI. And one really exciting opportunity with AI, and where I think it's going to change the type of research that we do, is one thing that modern AI or machine learning systems are really good at is working with what we would call in our profession primary source documents, and then making categorizations based off specific questions. One way, and it's not a full answer, but one way around your concern about producing data that may be inaccurate, that may have been categorized incorrectly, is if we are able to apply computational methods to primary documents at a new scale, that will be a responsibility that falls on the researcher, not on the court. And so instead of relying upon the courts to categorize and say, this is a contracts case, this is a family case, this is a whatever case, it's to say, these are our cases. And then it'll be on the responsibility for the researcher to make defensible conclusions about what that says. So AI is not going to save us, but it may enable new categories of empirical research and be able to put everyone in a more comfortable position.
Yeah, I think when we're talking about case law, we're talking about, as you were mentioning, Simon, we have good, we have case law that has consistent structure. We have good ways of disaggregating that information. The concern there, I think, has to do with the privacy concerns associated with releasing large bodies of court information and feeding them into an AI. So if we're hiding behind judicial independence there, that's probably the underlying deeper concern. And the nightmare that the court experienced when the Romanian website scraped its data, the letters that I got from concerned people about the privacy implications of their cases appearing on Google. The main thing that I don't see being addressed by those that, and I think, Julia, you're going to talk about this, about courts being, trusted custodians of data and information. I take that role very seriously, and so for me to be comfortable releasing information that is going to be disaggregated and fed into an AI, the corresponding assurance that at least at this stage I'm asking for, is related to the privacy concerns and the court's status as that custodian. And I know, Simon, you may have a different perspective on that.
I'm lurching. Yeah. So I have a few responses. So on the one hand, I'm kind of an open courts absolutist. Yes. On the other hand, I'm very concerned about privacy. And the thing that we need to, or the thing that I believe about this moment is we are in a absolutely catastrophic privacy moment that anyone could scrape Canley, and that's a concern. We know, I don't know, but I'm sure that all of this data has already been ingested into all the frontier models. That, part of LexisNexis's business model is to be a data broker. Where we need to be worried about privacy, in my view, is not at the release stage, it's at the production stage. And we require, I think, a sea change in how we write about cases, how we organize evidence. And what's exciting to me is a lot of this is already under the way. So if you look at the Veterans Review Appeal Board or a lot of the work at the Social Security Tribunal, those decisions, and I know you're talking about more than decisions, but those decisions are released in an extremely privacy protective way. And the journalists will have different interests, but when we think about data sets and we think about the production of legal data, there are lots of ways that we can write and produce differently in a privacy protective way that maintains our commitment to the open courts principle.
Hello. Okay, sorry. There's no light on it. So anyway, and I think you kind of touched on it, and I'll mention it a little bit more when discussing Dr. Panezi's paper, but the idea of who do you want the data to come from? Because we're either talking about this data coming from the courts as the source of knowledge, or as Simon alluded to, someone else scraping it being less ethically utilized, and then information being disseminated from the exact same data set, but from a lens that is incorrect or is more problematic. So I think we're there. I think we already have all this data that's out there. Someone's going to do it, and it should be from a trusted source as compared to the media, and not all the media is bad, but you know what I mean.
No. Courts certainly have, we certainly have a lot of concerns about the potential disaggregation and use of court decisions. And, that's something that has to be addressed. But look, this is a great discussion, but Julia, I do want to give you time for your presentation. So I'll just introduce you now, and we'll hear from Julia on the wonderful work that's being done in New Brunswick. So I'll just take a few seconds to introduce Julia. Julia has a JD from the University of New Brunswick. She's graduated with distinction and is a recipient of the Lieutenant Governor's New Brunswick Silver Medal. She's pursuing a Master of Interdisciplinary Studies in Law, Psychology, and Sociology in fall of 26, and she's a recipient of the SSHRC funding through the Canada Graduate Research Scholarship Program, and she's clerking at the New Brunswick Court of Appeal, and is going to be called to the New Brunswick Bar very soon.
The 15th of June.
Welcome, Julia.
Thank you so much. So obviously on the first slide, you saw that Dr. Argyri Panezi was going to be here. She unfortunately cannot be here today. There was going to be a video that she had prepared, but unfortunately, as it goes, there has been some technological difficulties. So what I'm going to do quickly is I'm just going to talk about a couple key pieces of information from her research. She wrote an article alongside the Honorable J.C. Mark Richard, the Chief Justice of New Brunswick, and I've been working as his law clerk this last year. So I've been working a little bit with them and kind of have a fairly good understanding of her paper. Obviously, I've read it and I recommend you read it. And I recommend that you watch the video, which I'm told will be made available. If there are any discrepancies between the points that I make today based on her paper, the truth and the reality and the accuracy is in the paper and the error is mine. So the paper was making a case that New Brunswick, as a smaller bar, a smaller justice system, acts as a good Canadian case study where both chronic access to justice problems and recent multi-stakeholder efforts to improve and modernize access to justice can be studied and understood. And what that requires is collaboration with the New Brunswick courts and community partners, as well as investments in modernizing the justice system, particularly in relationship to the handling of court information and knowledge. And as I was just saying, that's kind of the idea of where do we want this information to come from? Who should we trust? And how do we build that public trust? And the why, because the courts are credible sources of knowledge to the public and have a crucial role as trusted sources of information, as well as generators of knowledge that can help people to navigate justice-related issues. And the entire foundation of it is that access to knowledge is a requirement for access to justice. So access to knowledge and data as requirements, like how do you do that? How does access to knowledge relate to access to justice? And as I was saying, knowledge and not just information. So we have accurate, true, fact-checked, accurate information produced from the court as compared to news sources or other sources where we know that there can be misunderstanding or purposeful misleading, and we want to avoid that by having the courts provide that information. So what Dr. Panezi argues is that courts should be the data guardians for the public good by using this data, collecting it, curating it, analyzing the data through collaboration with community partners. So not as the only holders of the information, but as a source of that information. And one of the key points she makes is that it takes a village to build better futures, that recent efforts to improve access to justice in New Brunswick is not just the judiciary, not just judicial or government, but instead community-led efforts. So what is happening in New Brunswick is there is a New Brunswick Advisory Committee on Access to Justice. So in 2019, the Chief Justice, J.C. Mark Richard, and representatives of the court, the Minister of Justice, law schools, the Law Society, the CBA, and other key organizations came together and created a committee and recognized key issues of things like self-represented litigants as a serious access to justice issue. And they set priorities, one of them being modernization. And since then, there have been annual summits where we all come together. I say myself as well because I'll get to me a little bit in a little bit, but there's yearly summits where all these organizations come together and really discuss how things are going. Are we seeing improvements? Are there areas where things are not improving? Are we seeing areas of what we need to put more focus on for the next year? And those summits have been really informative because it brings together everybody who have these different viewpoints on how best to address this issue. And I think from my own perspective, as someone who comes from Ottawa, I come from this area, going into somewhere like Fredericton and New Brunswick and the smaller population, you start to recognize that you see this person over here, but they're also over here. And they're also doing something with the CBA while working with the Law Society. And also they run a nonprofit. So you kind of have that like institutional knowledge that's already there where you're already kind of seeing those working together, that working together model just by necessity. And it actually helps to see how all of those different understandings, all of that perspective can come together and work to make improvement where one viewpoint simply can't do it. We need that collaboration. And yeah, so there's a bunch in this paper that relates to the digital transformation and court data and AI, and that is not my wheelhouse or area of expertise. So I would say these individuals have provided a really awesome understanding, and also please read the paper for that part. So what I'm just going to say is that okay, so I'm going to say the next steps for New Brunswick courts that were identified in Dr. Panezi's paper is really just looking at the multiple benefits of data management, which includes gaining a deeper understanding of their own operations and identifying opportunities to improve based on evidence. And with more data, we can make more compelling cases for funding with more specific information. With sharing data, the court can provide insight into justice policy and other policy areas. The court can help democratize access to legal technologies, equalizing access to data in the legal tech market, and using data to drive innovation in the public legal service. And the court can maintain their role as a trusted source of knowledge about the justice system, both for the public and through building institutional memory, and that can counter mis and disinformation. So again, go ahead and read Dr. Panezi's paper. It is quite wonderful. I hope that was helpful. And I'm going to move into my presentation. So I am actually just here to share a little bit of my observations, kind of at the beginning of my legal career here, as observations from my time in law school as a pro bono. I was the Pro Bono Students Canada program coordinator for 2 years of law school, and really saw the impact and the importance of access to justice in relation to the various community partners that we worked with. And also I have some observations from my clerkship experience and have permission from the court to share a little bit on that. And and just my overall participation in access to justice initiatives. Ooh, okay. So I just want to give 3 simple examples of how data could help solve some of the problems that we witness and the things that I've observed and how data might be the way that we change that. And the first I want to deal with is data and responding to the needs of self-represented litigants. And for this, I'm just going to tell a little bit of a story. And it relates to my experience as a clerk. So one of the coolest parts about being a clerk at the Court of Appeal has been getting to go to cases, getting to see people advocate, getting to see individuals come in contact with the justice system. But something that became incredibly apparent very early on is that our court time is not being utilized well because of problems that start way before someone steps foot in the courtroom. And one of those examples is self-represented litigants who are imprisoned and who are self-representing at their appeal. So what we have is we have the ability to bring these people through Zoom calls into the courtroom. And a common occurrence that led to adjournments multiple times over the year that I was there were prisoners who did not get access to their documents, did not have help with legal aid, did not have any assistance within the prison to help them prepare themselves for their appeal. And they would come to the appeal and ask for legal counsel. Or they would come to their appeal and they would say, I got 3 pieces of paper and I didn't even know this was happening today. And those kinds of things were quite common. So from a clerk perspective, I'm watching this happen and I'm seeing all of this court time, the time of lawyers, you're like, really, I love your energy. Like yes. Okay, so this problem of we're seeing court time that isn't being utilized. We're seeing judges who are ready and counsel who is ready, the court system that has prepared this whole thing, and then an individual whose rights are on the line. So we very rightly adjourn the case because their rights are what matters, but we lose all that court time. And, okay. I'm bad with the time management. So I know in my own head thinking like, how can we improve this? And the Chief Justice and the prosecutors and the defense attorneys, or defense counsel, got together and came up with a solution of allowing for case conferences prior to an individual's self-rep's case. So what that would allow for is that there's a status hearing, and that status hearing would allow them to see if that individual was ready to go for their appeal. It was through the registrar holding those. And what that was a very simple solution to a very real problem, right? And I think, I think we can see that that was an observation that occurred multiple times in order for us to see we need to do something. And that's data, right? We have a data on these adjournments that are caused by individuals not being ready, and we implemented a solution, and that is saving court time. So that's the kind of thing that I think that data could be used for. That's one of those arguments for increasing our data so we can come up with innovative solutions. Another one, through my work with Pro Bono Students Canada, one of the issues that often arises for community partners is difficulty in getting funding. So we have these incredible services that are essential to individuals in our societies, but they're scared every year of losing their funding because they can't make the best case possible for their continued importance in the community. And when we have something like that happening for individuals who are precariously housed or victims of sexual violence, we're really losing essential services based on a lack of data for organizations that are already running on fumes, organizations that are already putting Band-Aids on bullet wounds because they're just trying to get services to individuals. So what data would allow us to do is help increase the efficacy and the rigor of these funding applications. It allows us to make better cases to support these ongoing initiatives. And finally, one of my master's thesis is going to be on mental health and wellness in the legal profession. And one thing that I believe that data can really help us with is understanding the burden that is placed on legal professionals. I notice I say often about adjournments, but one thing that, well, first I want to preface this by saying this is all kind of my brainchild right now, and I recognize that there are issues with ethical and confidential collection of information and collection of data. So that is something that still needs to be considered. I have not done my thesis yet. It is TBD. But one thing that we can do is collect data that helps us understand the experiences of individuals working in our profession, because mental health and wellness in our profession is an access to justice issue. If we fix all of the problems that get people to the door, but then when you get to the door, there's no one there to help you because they're burnt out and they're leaving the profession, we still got a problem. So we got to work on both sides. So my thesis is surrounding that issue. So a couple ideas of data, one of them on reasons for adjournments. I'm sure all of us who work in the profession or have seen cases being adjourned because lawyers have gotten ill and are unable to continue their practice or leave the practice. And all of those things are related, that may be related to a mental health and wellness issue. And if we can collect data on struggling, then we might be able to better respond to those issues. If you guys have not read the Kadzir report on mental health and wellness in the legal profession here in Canada, it's a really amazing, fulsome report by psychologists at the University of Sherbrooke that really looks into, really has data on the experiences of legal professionals. And it's been really eye-opening. And while they obviously frame it from a psychological point of view, I'm hoping to use some of that information to make the case for access to justice. The whole idea, if there are high attrition rates, less lawyers, less access. Another key issue of overwork, we may be able to collect data on appearances and the number of times a lawyer is in court. And if they're there all day, every day, I can't be 24/7, but you know what I mean. Then maybe we have some data where we can start to say, okay, maybe we need to set some limitations to ensure that people are not working themselves sick or being worked sick, depending on the situation. So that is everything from me. I hope that was informative, and thank you so much.
Thank you very much, Julia. We have some time for questions from the floor, so we've got about 5 minutes. If anybody wants to come up to the mics and ask a question, please go ahead.
Simon, I'm curious, as a refugee lawyer, do you see refugee law practice as an area in which this type of data liberation or data privacy that you're calling for would change the state of play?
Yes. and I think one thing that we're particularly interested in is not just refugee law, but all those areas of mass adjudication. So social benefits, human rights to a lesser degree, immigration cases, refugee cases, landlord-tenant cases, anywhere where it's not a boutique area of adjudication. And you get really interested in those questions about inconsistency, debates that bubble up, how they get resolved. Those places are the areas, I think, ripe for computational intervention.
When you say inconsistency, you mean like same facts leading to different outcomes with different adjudicators?
That one example, yeah.
Hi, everybody. Very interesting. I've sort of got a question that sort of sits between Timothy's perspective and Simon and Jeremy's perspective here. I have definitely asked many courts in Canada, including Canley, for data and have been rejected, and I have also been barking up this tree for many moons to very little progress in that way, and I do very much understand courts and Canley saying this isn't clean data. There may be a huge amount of private information, personally identifying information. You're just a researcher or you're just an academic. We're not able to verify that you're going to be able to handle this in an appropriately secure way. What about an intermediary organization that sits between, that is able to align with the funding capacity and interests of courts and of researchers and of the public, whether it be provincial, federal, whether it be co-staffed by courts? What about an intermediary organization who is the guardian and the steward and is appropriately resourced in order to handle these matters? Data is a very complex thing that requires special training in a lot of contexts, and courts don't always have the funding to hire people and pay for that sort of thing. So just that this is not a plan question, it just sort of came to my mind while I was listening to everybody speak. What about an intermediary organization that could be responsible, could be the guardian and the steward and the trusted party who could steward this information between the courts and the public?
So in Quebec, you're going to have to forgive my Anglo accent. Socage? Yeah. Socage. There's socage, which is like that. And there's every reason, I think, to have that in different jurisdictions and nationally. The other thing I would say is nationally, at least when you're concerned about my issue, and my issue is about those texts, and my issue is more specifically about ensuring equal access between people who have billions of dollars and people who don't. That's my thing. And Canley could solve that problem tomorrow. Canley could solve that problem tomorrow, and that would get us a long way away there. And Canley is pretty close to being a trusted repository of one category of judicial data. And it would be, in my view, much better for Canley to put that aspect of our initiative where we are collecting and publishing case law. It would be better for Canley to make that initiative redundant. And then we can go do the weird studies that we want to do instead of replicating that work. That seems silly.
And I'm going to sound like a broken record, but the National Center for State Courts is absolutely that kind of organization, and they have the expertise, the resources, which comes from courts, but states and researchers. And what's really interesting in what they do, and they're not perfect, of course, but what's interesting is that they gather data, they analyze it, but they also transform that into materials that can be used for judicial training as well afterwards. So, for example, with respect to juries, they have done studies of how courts deal with juries, how juries respond to what courts are doing, and then feeding that back into court processes. So it's a feedback loop that we don't really have here, but with collaboration, I think we could get there.
I'll just say this one other point, and that is that the idea that Canley, Thomson Reuters, and others don't already change judicial decisions is not well understood. I think I have pretty constant discussions with Canley and with private publishers about changing styles of proceedings, adding summaries, and modifying court decisions. There's a reason why I stick very closely to the idea of self-publication. I'm one of the few courts in the country that still self-publishes, and I do it for the reason that Julia alluded to, and that is, if you want the original, you've got a place that you can go. It's not been touched. So I have this, I like the idea of an intermediary. Anything that will help me introduce expertise, the desperately needed expertise that I have to build a repository of data that is accurate and that can be released without some of those anxieties. I welcome it. So, excellent idea. One more.
Thank you. About a month ago, the Court of Appeal for British Columbia posted on LinkedIn, an appeal is allowed when the court overturns or varies the order under appeal from the lower court or tribunal. In 2025, the court allowed 35% of the total appeals heard, 127 of the 360 appeals. The proportion of civil appeals allowed was 35%, 97 allowed, 182 dismissed. For criminal appeals, it was 37%, 30 allowed, and 51 dismissed. And I posted a comment underneath asking, in the interest of access to justice and transparency, could you please provide a breakdown of these outcomes by represented versus self-represented parties? I wonder if the courts do capture the data in regards to self-represented and represented parties, and if so, why not, or maybe what needs to change in order to do that? Thank you so much.
Yes, so our court provides information about self-represented litigants. So we were steady at around 22 to 25% for years and years and years. And just in the last 3 years, we've seen an increase up to about 39% of civil cases in the Court of Appeals. So it's interesting, and I think Mr. Nedoletsky has some comments on this because he's been studying this in great detail. I know he's on a different panel. But we were actually steady for many years with self-represented litigants. And interestingly, we break it out by family as well in our court. So we know that in family cases, it leaps up to about 59%. So it's more than half, right? Which gets you really thinking about the designs of the system, because if you got more than half of people coming to the court who are self-represented, why are you using a system that's designed for lawyers? So, you have to think about those sorts of questions. Now, do we break it out on criminal cases? Do we break it out? We do that too. So in most criminal cases, people end up being represented by legal aid. But I think it is important because this is central for us to break out in as much detail as possible self-representation. And no, I don't publish statistics about how many self-reps are successful on appeals, but it's probably a good idea.
One thing I would just like to note is that in New Brunswick, we don't have that data. I preface that, there's a caveat. I know that the Chief Justice of New Brunswick keeps that data himself. Like, he does that. He keeps it in an Excel file, right? And he's showed it to me. So the information is there. But when the Chief Justice of New Brunswick goes supernumerary or retires or does something else, that goes away too. It doesn't continue, right? And I want to also say that the Chief Justice of New Brunswick really cares about data. He co-wrote that paper. He is a proponent for access to justice, access to knowledge. And that's why he does it, right? He does it because he cares about this, but there's no system. So that's really just a push to say we need systemic data collection because the Chief Justice of New Brunswick is not going to be there all the time. And we need this to continue after he has, when he retires and gets to enjoy all the amazing work he's done.
Excellent. Well, thank you, Julia. And I think we're over 5 minutes over time here. I've kept everybody here for extra 5 minutes, but I want to thank everybody for their presentations today. Thank you so much.